My dad gave me $1 bill because I'm his smartest son. And I swapped it for 2 shiny quarters because 2 is more than 1. And then I took the quarters and traded them to Lou for 3 dimes. I guess he don't know that 3 is more than 2. And then along came old blind Bates, and just 'cause he can't see, he gave me 4 nickels for my 3 dimes, and 4 is more than 3. And I took the nickels to Hiram Coombs down at the seed feed store, and the fool gave me 5 pennies for them, and 5 is more than 4. And then I went and showed my dad, and he got red in the cheeks and closed his eyes and shook his head, too proud of me to speak. Well, that, as all elementary school graduates know, was Smart by Shel Silverstein. This is Short Circuit, your podcast on the federal courts of appeals. I'm Anthony Sanders, the director of the Center for Judicial Engagement at the Institute for Justice, and we are recording this on Friday, December 2nd, 2022. Now, as that poem might indicate, today we're going to be talking about money, the coin of commerce. You know, the Constitution and liberty, those are important things. But at the end of the day, we want to talk about cash. Cash is king. And so I have assembled 2 of the Institute for Justice's most accomplished financial gurus to try to walk us through some financially minded circuit court opinions. First of all, I would like to introduce to everyone an old friend of the show, Rob Peccola. Rob, welcome back to Short Circuit.
Great to see you on this lovely Friday, Anthony, and even nicer to see Bert and welcoming him to his first appearance on Short Circuit.
That's right. Our other guest is an old friend of IJ. He has worked for us for many years and done all kinds of things. He has accomplished great victories in every one of our pillars: school choice, economic liberty, property, you name it, he's done it. These days, Bert is kind of like the guy behind the guy behind the guy. And I thought I'd take him out from behind the curtain, or at least his voice, and share him all with you. So as Rob says, Bert, welcome to Short Circuit. Very good to have you on for your first time.
It's great to be here. You know, longtime listener, first time caller. Now that's probably a reference only folks, Gen Xers and maybe early millennials will get. But I'm ready to rock and roll. Let's go.
Okay. Well, I don't think we have an exclusively Gen Z audience, so hopefully a few folks did get that reference, and hopefully they still read Shel Silverstein in the schools these days. I know my kids did. So. We're going to first go to Rob. So we have a case about bankruptcy and then a case about attorney's fees. But don't worry, they're much more exciting than those sound. Both very important things to many lawyers and many normal people, of course. So Rob, take it away with a little bankruptcy.
Well, Anthony, even though we're talking about bankruptcy, we are still not straying far from the Constitution. Article 1, Section 8 of the Constitution, in fact, gives Congress the power to create uniform laws regarding bankruptcy to attempt to treat debtors fairly throughout the country. And we often talk about people being morally bankrupt or artistically bankrupt. But we constitutionally and legally, we have something different than our colloquial understanding of bankruptcy, which is a highly codified system for establishing what to do when you are out of money and you have creditors and they need to be paid. And the Second Circuit recently took up Congress's bankruptcy scheme in a case called Clinton Nurseries, where a plant grower was going through the bankruptcy process and encountered some unfairness in the fees that they have to pay. So what you have in the bankruptcy system is essentially two systems, one for Alabama and North Carolina and one for the rest of the country, where
makes perfect sense.
where through legislative compromise, you have trustees whose job is to be fiduciaries for getting people paid, who themselves have to be funded. And in these parallel systems, you essentially had a situation where one system of trustees had their fees go up, and another system with the bankruptcy administrators, or the BAs in those two states, did not. And that would be very frustrating if you were a debtor, to know that you were subject to these fees when others weren't. And we're talking about a lot of money here, several $1 million. And if you go through the opinion, they actually break it down. And I didn't know this, but the fees are pretty hefty. It's a quarterly fee that you pay to fund this system as a debtor. And in this 2017 amendment, which is refreshing, I think, because Congress actually passed this fee increase because bankruptcies were going down at the time, which is a good thing. So we're talking about, close to $10,000 a quarter for a bankruptcy estate of this size. And what we had was the U.S. Supreme Court weighing in and saying, hey, we're not treating people fairly here. There has to be uniformity. That's what the Constitution calls for. And the Second Circuit, taking a second pass at this Clinton nursery case, decided that indeed, you can't have parallel systems that are charging people different amounts when the Constitution says that we need to treat debtors in a uniform manner across this great nation. So it's an interesting case, and it's one that I think can touch on some of our constitutional issues at IJ, sometimes even more than we know. Recently, and for example, in our Memphis Environmental Court, one of our clients was dealing with a bankruptcy. And fascinatingly and somewhat troublingly, bankruptcy courts essentially treat you like you're dead. They own every aspect of your bundle of rights that you carry around as a person, including constitutional claims. So we had to effectively release those constitutional claims before we could bring them in federal court. So this is serious business, and it touches on all aspects of our system of litigation, including constitutional law.
Bert, how many times have you declared bankruptcy?
I have never declared bankruptcy, although one of my favorite episodes of The Office was when Michael Scott declared bankruptcy by simply walking through the office and yelling the word repeatedly. But
it doesn't work that way, I understand.
It doesn't. Oscar had to walk Michael through the fact that there's a process. And Scranton is neither in North Carolina nor Alabama. So it's part of the, I guess, what would you call that? The regular bankruptcy system, Rob?
Yeah, I would say that's about as regular as it gets. The trustee system, where these good folks get on the trustee wheel, it turns, and they end up handling a bankruptcy.
Yeah, for listeners who never been through the process yourself, either yourself or your business, or have never represented clients in a bankruptcy proceeding or made claims in one. It's you're right that it's the trustee. It's not the debtor who's really the client there. It's the debtor's stuff, and the trustee does all kinds of things, and of course that trustee needs to be funded somehow, and I had no idea about this fee system. The really interesting thing to me is, right, so for people who care about things like enumerated powers in the Constitution, where there's these powers listed in Section 8 of Article 1, and Congress supposedly doesn't have powers beyond just those listed and a few others elsewhere in the Constitution. The fact that there is something like as specific as bankruptcies seems to indicate that the separate power to regulate commerce among the several states isn't like everything, because then you wouldn't need the subject of bankruptcies, because bankruptcy sounds a lot like commerce. Of course, the modern Supreme Court has basically washed all that away, and commerce has come to mean almost everything. So the powers of Congress are very broad. But it's like the Supreme Court, though it's done all that, has tried to keep a little bit of the original text of the Constitution in play. And it's interesting it does it here, where it says uniform laws on the subject of bankruptcies throughout the United States is the text. So that even though there's separately the Commerce Clause and the Necessary and Proper Clause that would allow, very arguably these days, legislation about bankruptcies, including having different fees in different places, because that text is there, it's kind of like a residual stop on these expanded powers of Congress. And so, the court points this out, that, even though maybe you could do it through the Necessary and Proper Cause, we can't just ignore this text. So it's a restriction on Congress's powers, or at least a mandate that Congress's powers have to be done in a certain way, even though you could arguably do it a different way, which is, for those of us who aren't big fans of that modern jurisprudence, it's a little bit of solace on what the court could do.
Well, it's interesting, too, that some of these concepts that we think of as being at least somewhat modern actually go back to the founding. Another example would be copyright, where we go back to the actual text of the Constitution, and there similarly was an 18th century understanding that there would be a role for the federal government and for the courts to enforce people's intellectual property rights. Similarly, the way that we treat creditors, trustees, and debtors has that 18th century predicate too. So it's also a testament to the foresight and the prescient understanding of how our society would deal with these somewhat esoteric rights.
Yeah, and one other interesting thing that, maybe I thought about in law school, but I certainly haven't thought about in a long time, is you go through the powers of Congress in Article 1, Section 8, and there's a lot about to regulate commerce with foreign nations, to coin money, to provide for the punishment of counterfeiting, a lot of these specific things. But the uniform only comes up with they're in the same clause, bankruptcy and naturalization, to establish a uniform rule of naturalization and uniform laws on the subject of bankruptcy, so that the convention was concerned about the Congress's powers, but concerned about uniformity specifically in these two areas. And it kind of reminds, naturalization, that makes sense because the federal government was going to have the sole role for foreign affairs. But uniform laws on the subject of bankruptcies is a special thing. They wanted to especially have Congress the power of, probably because of things like Shays' Rebellion that led to the actual Constitution in the first place. Well, I'm glad, Rob, that we have these fees worked out, even though they're pretty hefty. But I guess you have to fund the system somehow. Another thing that can be very hefty, but often not hefty enough, are attorney's fees in civil rights cases. Now, Bert, I believe you have tried to get attorney's fees in the past for some of your victories. So maybe walk us through how that works and how sometimes courts are a little reluctant to hand those out, although it doesn't seem like they were in this case.
Sure. Yeah. And we, have a really interesting case about attorney's fees. And I promise our listeners that attorney's fees is actually a very interesting.
Well, the attorneys listening will be very interested, I'm sure, but even non-attorneys.
And I hope so, even more broadly, because attorneys' fees are a mechanism that appear in multiple federal statutes when it comes to the enforcement of rights, whether those be statutory rights, or as in this case that we're dealing with from the Sixth Circuit, the Tennessee State Conference of the NAACP et al. Versus Trey Hargett for civil rights litigation under the Constitution. And the governing statute there is Section 1988. It covers attorney's fees. And like many fee-shifting provisions, it awards fees to the prevailing party in civil rights litigation. Now, a lot of ink has been spilled on what is a prevailing party. And in 2001, the U.S. Supreme Court, in a case called Buchanan versus West Virginia, some department or other, basically said, look, in order to be a prevailing party, you've got to secure yourself court-ordered relief. So it's not enough for you to file a lawsuit and accomplish your goals, but not get some sanction from the court, of that relief. So if you don't get a judgment, if you don't get some sort of a court-ordered settlement, you're out of luck when it comes to getting attorney's fees. Now, that was a 5-4 decision, pretty hotly contested. And up until that point, every single circuit to consider the issue had embraced something called the catalyst theory, which is that, if I file a lawsuit, but I get the government to change its behavior as a result of my lawsuit, I'm going to get attorney's fees because I have succeeded in my objective. I mean, after all, a civil rights litigant doesn't file a lawsuit to get a piece of paper from the court saying kind of, attaboy, good job, you're right. No, you actually file a lawsuit in order to accomplish something practical, to have the government stop doing something that is infringing upon your rights. And so every circuit had said, yes, the catalyst theory, that's right, that's what Congress intended. The Supreme Court said 5-4, no, that is not what's intended. And so then you have subsequent litigation, about if the relief has to be court-ordered, what kind of relief can that be? Because litigation often terminates before final judgment. Sometimes it terminates right after you file a lawsuit and you secure a preliminary injunction stopping the government from enforcing an unconstitutional law. And that's what happened in this case, where you had the Tennessee State Conference of the NAACP and others sued Tennessee because Tennessee in 2019 had enacted a series of laws that really kind of made it onerous to conduct voter registration activities in the state. And so Tennessee got sued very promptly, and they lost. Basically, the parties had extensive briefing on a preliminary injunction with lots of exhibits, lots of briefing, and the district court said, I find that the plaintiffs are very likely to succeed on the merits. I'm going to enjoin the enforcement of all these laws. And, shortly thereafter, the Tennessee legislature repealed all of those laws. And the plaintiffs, requested attorney's fees, as they were entitled to do under Section 1988. And they secured attorney's fees, but that proved controversial before the Sixth Circuit because they had not secured a final decision from any district court. And so the question was, while it has been established that you can get attorney's fees for a preliminary injunction, apparently in the Sixth Circuit that is generally disfavored. And the Sixth Circuit, by a 2-1 vote, upheld the award of attorney's fees and said, look, in this case, even though the government basically withdrew before a final judgment was reached, and even though that normally means that you're not a prevailing party, the fact is the plaintiffs here secured a preliminary injunction that all but ended the litigation. And the state never appealed from it. This case was extensively briefed. Everything was aired out, and the plaintiffs were able to conduct voter registration activities for the upcoming election unimpeded by the law. So they're a prevailing party. But the dissent said, wait a minute. No, that they should not be considered a prevailing party because the relief that the plaintiffs secured here was not enduring. And by enduring, what what the dissent meant was, look, they wanted relief not just for the upcoming election, but all future elections. And they didn't get that because the government withdrew, the laws. It repealed the laws before a final decision was reached.
Well, they kind of did get that in a sense.
Well, yeah, they did. And
and
that's why I think the dissent's on the wrong end of things here, because and the opinion's fascinating because if you're kind of almost an existential discussion of like what is enduring, the majority clearly says, look, no, this was enduring. Because they secured relief that was irrevocable. They got to conduct voter registration activities. The dissent says, look, under Buchanan, we should have essentially a bright line rule that if you get a preliminary injunction, but the government voluntarily eliminates the offending legislation, that's not enough. You're not going to be a prevailing party. The majority rejects that and then says, no, that's not the case. And it does say you're not going to be a prevailing party to get attorney's fees in every instance where you've obtained a preliminary injunction. For example, if you obtain a preliminary injunction and you lose on the merits, the Supreme Court has already said you're not going to get attorney's fees for securing that preliminary injunction because the relief that you got was fleeting and not enduring. But this topic is a very important one because Congress intended by use of fee shifting statutes for vigorous enforcement of civil rights laws and the Constitution, and to incentivize the vindication of those rights, because as we all know, the government is not going to police itself. And that's why there's a big fight over who's a prevailing party or not. And from the perspective of a civil rights litigator, I think all of us have seen all too often the government gets caught with its hand in the cookie jar, it gets sued, and it looks like it's going to lose. And it then, basically repeals the law in question in order to try to moot the case and avoid attorney's fees. And that's, that is a common problem and one that you often have to deal with. I mean, I think the original sin here goes back to the Buchanan decision and its, read of prevailing parties. I analogize this to a little bit like a football game where, let's say one team is beating up on the other one and up by like 5 touchdowns with 2 minutes to go in the fourth quarter. And the other team just says, oh, we're just going to walk off the field. So, you're not going to get a final score. Sorry. And does that mean that the team that was up by 5 touchdowns shouldn't prevail? No, in the real world, the losing team forfeits. But under the rejection of the catalyst theory basically means the government can be down big late and can just walk off the field and not have to pay for the constitutional wrongs it has inflicted, upon its citizenry.
Rob, what does enduring mean to you?
Enduring to me means that you got what you came for. And that in this context, I think enduring means that you will wake up tomorrow with the relief that you sought. And it's interesting what the point that Bert made about the underlying policy objectives here. And it does make you sort of read very closely the dissent to think about how it's treating the seriousness of some of the underlying constitutional violations and the importance, A, of making sure that those are resolved, and B, making sure that the incentive is there to bring those in the first place. I noticed that the dissent had heavy use of contractions, sentences that consisted of 2 words. In some ways, the style of the writing was in keeping with the view expressed.
We'll leave it there about the dissent. I had a similar reaction to both of you, unsurprisingly. The other angle on this case is as with many cases, especially a case about election law or voting rights, is the defendants here are state officials, and because of various reasons of sovereign immunity, you can't sue them for money. So you couldn't add on, some damages for violation of your rights in this case, or in all kinds of other cases in different contexts, whether it's voting rights, property rights, what have you. And so you can't get a judgment if the law is repealed because you can't get money damages. And so the only thing you're left with is declaratory injunctive relief, like they're asking for here. And so if the state can just get out of it by repealing the law, even after you get a preliminary injunction, that seems like even more contrary to what Congress was going for, because Congress, didn't pass this statute to say, well, if you're already getting a lot of money from the government, then you can get some attorney's fees. I think it would be the opposite, that if all you can get is an injunction and you're a civil rights attorney trying to help some people out whose rights have been violated, that the court has adjudicated the rights have been violated, then you should get some attorney's fees. But because of how our system works and sovereign immunity and all that, and not to mention qualified immunity, if it was a case where that could be at issue, it's the opposite. So this is trying to get a modicum of Congress's intent in trying to effectuate its civil rights statutes by having a mechanism for attorney's fees. It is interesting that it is actually still an open question, because I've researched this in some of my cases in the past, that at the Supreme Court level, that a preliminary injunction qualifies for attorney's fees under the civil rights statutes under Section 1988. I think just about all the circuits have said that it does qualify, and certainly the majority here is, but this dissent does not agree, and I really hope that the Supreme Court never goes along with that, and I think that the Supreme Court would say that this qualifies, but it's interesting to note that has never fully been squared, that a preliminary injunction qualifies you for attorney's fees, even if that's all that ever happens in the case.
Yeah, and even the majority here is pretty careful to say, look, on this record, we have a situation where this case was practically completely litigated, at the preliminary, injunction stage. And if we had a situation where it was, much more fleeting, had they lost, at the district court, level, for example, on the merits, they certainly would not have gotten a fee award or not been entitled to one. But again, like the state denied them that because they saw that they were about to lose. And I really do want to stress why fees are so important, because litigation is expensive, and you're not going to have a vigorous enforcement of civil rights laws across the entire country if there is, if essentially private attorneys generals can't get compensated for, their, attorneys' fees in order to vindicate those rights. Congress recognized that and said, look, these rights are great, but they're nothing without, vigorous, enforcement across the board. And, now making fees harder to obtain makes it essentially harder for folks to bring public interest litigation. IJ, ICLU, other groups, we can't bring every public interest lawsuit across the board. There are lots of attorneys, solo practitioners, attorneys working pro bono for their law firms. that they're the ones who really need to be like incentivized to help vindicate civil rights.
Well, I'm glad that we started with the cold coin of commerce, and now we've ended up with vindicating civil rights. Even if money makes that a little easier sometimes. So I appreciate that, Bert, and I appreciate Rob, you coming on as well. I hope both of you guys have a very happy holiday season as we speed along to the end of December. But in the meantime, I hope all of you listening have a happy holiday season. And I want all of you to get engaged.